Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineered. Good day to all the viewers, especially to all the students who are tuning in to this YouTube channel. Again, I'm Attorney Bendrick E. Maralit.
And I'm Attorney April Uy.
And we are here to discuss to you Module 5, Extinguishment of Obligations. So, Attorney Uy, let's go straight ahead to the general provision under Extinguishment of Obligation, Article 1231. What does it provide?
So, Article 1231. Obligations are extinguished first by payment or performance, second by the loss of the thing due, by the condonation or remission of the debt, by the confusion or merger of the rights of creditor and debtor, by compensation, by novation. Other causes of extinguishment of obligations such as annulment, rescission, fulfillment of a resolutory condition, and prescription are governed elsewhere in this code.
Alright, so self-explanatory naman yung Article 1231
Yes.
kasi it provides the modes of extinguishment of an obligation. But we have to let you know that in addition to those provided under Article 1231, for the causes of extinguishment of obligations, kasama din dyan yung death of a party in case of an obligation requiring personal service under Article 1311, paragraph 1.
And yung mutual desistance or withdrawal of the parties.
Kasama rin dyan yung arrival of resolutory period under Article 1193, paragraph 2.
Yes, and yung compromise under Article 2028 of the Civil Code.
Also under Article 1266, impossibility of fulfillment.
And yung happening of a fortuitous event under Article 1174.
Alright, and these causes, itong mga nasabi namin, are those enumerated in the second paragraph of Article 1231 and they are governed under other chapters of the Civil Code. Ngayon, iisa-isahin natin ito. That's our goal in this module. Isa-isahin natin ang modes of extinguishment.
Yung primary modes of extinguishment under Article 1231.
Okay, so medyo bago to sa mga tagapakinig natin. And mahalaga na isa-isahin natin ito kasi may mga technical definition talaga ito by law. So unahin natin ang payment. Ano bang meaning ng payment, Attorney Uy? Kasi under 1232, ano bang pinaprovide nun?
So sabi, payment means not only the delivery of money but also the performance in any other manner of an obligation. So, kasi yung in ordinary parlance, payment refers only to the delivery of money. Tama nga naman. Sa Tagalog din, nagbayad. Pera.
Pagbibigay ng pera. Pero dito, may...
Under Article 1232,
as a legal mode of extinguishing an obligation, it has a much wider meaning. Okay, so payment may consist of not only in the delivery of money, but also the giving of a thing other than the money. The doing of an act or not doing of an act. Kasi tatandaan natin, di ba, sa obligation, di ba, under Article 1256, an obligation is a juridical necessity. Under Article 1156 of the Civil Code, an obligation is a juridical necessity to give, to do, or not to do. So, the fact na ibinigay mo, which is incumbent upon you or yung in-expect sa'yo, that can be considered as a payment. So, kaya mahalaga na maintindihan natin na ang payment under extinguishment of an obligation is not just about money.
It is not confined only to the delivery of money or payment of money, but also to the giving, or doing or not doing a certain act.
Yes. So, for example, then, when a debtor pays damages or penalty in lieu of the fulfillment of an obligation, there is also payment in the sense used under Article 1252. Right? And, yung bang payment and performance, Attorney Uy, are they different pagdating dito sa extinguishment?
So, in law, payment and performance are synonymous. So, ibig sabihin yung performance of an obligation, it also, or performance of an act, it may also constitute as payment under Article 1232.
Teka, medyo lumalaon na tayo, no? Sa Tagalog, lumalaon is nagproceed na tayo further. Pero ano ba yung pinaka-effect nitong extinguishment nga muna, Attorney Uy?
Ang effect ng extinguishment, from the word itself, extinguish, it will terminate or it will cause the death of the obligation. It will put an end to the obligation.
Kasi tandaan natin, di ba, pag may na-constitute ng obligation, of course, merong duties and responsibilities ang parties to one another sa debtor and creditor, obligee and the obligor.
Yes.
Pero kapag nag-exist itong pinag-uusapan natin ngayon ng modes of
Modes of
extinguishment,
yung payment, yung loss of the thing due, yan. Yung
it's as if wala nga ng agreement between the parties, okay?
it will cause the termination or the death of the obligation already existing.
So, since pinag-usapan naman na natin yung payment as a mode of extinguishing an obligation, palalimin natin itong discussion natin dito. Ano ba yung sinasabi sa Article 1233, Attorney Uy?
So 1233, a debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered as the case may.
Okay.
Yan.
So, ibig sabihin yan, yung may pinag-usapan kasi ditong debt.
Yes.
No? Ano ba itong debt na hindi ito yung death na kamatayan, okay?
Debt
So,
as in utang.
Utang, ayan. A debt,
Utang.
yes, utang. A debt may refer to an obligation to deliver money, to deliver a thing, other than money, of course, to do an act, or to not to do an act.
So a debt does not necessarily mean na may utang kang pera. Kundi pwede din itong delivery of a thing, pwedeng to do an act or not to do an act.
So kapag may debt ka, of course, meron kang
Corresponding obligation to
pay the debt. So, payment. Kailan ba natin mako-consider na ang debt ay paid? Or when is a debt considered as paid, Attorney?
So, under Article 1233, meron dalawang requisites. Una, yung integrity of prestation at padalwa, yung identity of prestation.
So, puntahan natin yung integrity of prestation. Yung ibig sabihin lang yan, a debt to deliver a thing, including money, or to render service is not understood to have been paid unless the thing or service has been completely delivered or rendered, as the case may be. Again,
so in short, kailangan complete ang payment. At ang nakalagay dyan, partial or irregular performance or payment will not produce the extinguishment of an obligation as a general rule.
So, bigyan natin ng example yung integrity of prestation. Halimbawa, si seller S, he obliged himself to deliver, let's say, 100 sacks of rice to the buyer. However, upon the delivery, si S, nag-deliver lang siya ng 90 sacks of rice.
Yes.
Would you consider that as a payment on the part of the seller S on
So,
the issue of integrity of prestation?
So, under the law, there is no payment by the seller. And the buyer can refuse to pay the 90 sacks if the seller does not deliver what is lacking or yung 10 more sacks of rice.
Bakit nga natin nasabi, Attorney, na there is no payment on the part of the seller in that?
Kasi partial pa lang yung payment. Partial pa lang yung performance.
Sinabi sa integrity of prestation na
Kailangan
dapat complete.
Kailangan 100. Kung 100, 100. Hindi pwedeng 90, hindi pwedeng 99.
That's correct. Okay. So, puntahan natin yung pangalawang sinabi mong requisite.
Yes, yung identity of prestation, meaning the very thing due must be performed or delivered.
Halimbawa, dun sa una natin example kanina, si seller S, he obliged himself to deliver 100 sacks of, let's say, sinandoming rice.
Pero ang dineliver, 100 sacks of NFA rice. Complete yun kasi 100 sacks. But sa identity of prestation, babagsak. Kasi kailangan yung the very thing due must be delivered.
So take note, in order for a debt to be considered as paid, there are two requisites: integrity of prestation and the identity of the prestation. So para dapat ma-comply with yun. Okay?
Okay. So let's proceed to Article 1234. Yung if the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee.
Ayan. So, Attorney, ito na yung sinasabi natin kanina. Di ba kasi sinabi sa 1233?
Yung integrity.
Oo, meron tinatawag na that's the general rule, yung 1233. Kailangan integrity of prestation, identity of the prestation. However, the Article 1234 is the first exception to the general rule.
First exception to the general rule. Yung 1234, yan yung substantial performance or substantial compliance in good faith.
So, in such a way, even if hindi naman talaga complete
yung performance,
pero there is substantial compliance in good faith, the law considers the debt as paid.
Paid.
And there are certain requisites that must be complied with before you can apply Article 1234.
Kasi
And
exception siya eh.
Yes. And the requisites are first, sabi ni Attorney Oy, there must be substantial performance and
the obligor must be in good faith.
okay. So, dalawa yan. Nasabi mo, Attorney Oy, that there must be substantial performance.
Yes.
Ano ba ibig sabihin yan?
Yes, yung there is substantial performance when the important or essential part of the contract has been performed and only a small or minor part thereof has not been carried out.
Alright, so since Attorney Oy discuss mo naman yung kung ano ba yung substantial performance.
Performance.
Siguro, gusto ko lang i-reiterate sa mga bata or sa mga nanonood sa atin na yung Article 1234, ito daw yung tinatawag na Doctrine of Substantial Performance.
Yes.
We have to differentiate that with Article 1235 kasi 1235 talks about
Partial
performance.
performance.
Okay. So, siguro, bigyan lang natin ng example sila
Yes.
para mas maging malinaw sa atin. Attorney Oy, ano bang pwede natin maibigay na example?
So, the seller obliged himself to deliver 500 bags of cement to the buyer for a certain price. However, despite diligent efforts on his part, the seller was able to deliver only 400 bags because of cement storage.
Shortage.
Cement shortage. So, dito naman, we can infer that the seller wants to comply with his obligation to deliver the entire 500 bags, but he could not do so for reason beyond his control. So, it shows good faith.
Ayun na yan. Kasi nag-attempt naman talaga siya. Naganap siya ng,
Yes.
ng 500 bags. It's just that
May
after
cement
diligence
shortage.
niya,
Oo.
may cement shortage nga. So, hindi niya makomplete
Beyond
yun.
his control na yon. So, under Article 1234, the seller can recover as though there had been complete delivery less the price of 100 bags of cement. So, the seller must show, however, that he attempted in good faith to comply with his obligation.
Since this is the exception, di ba? Ang sabi natin kasi the general rule is that if there has been no integrity of the prestation, there's no complete performance, then it could not be considered as a paid or a valid payment.
Yes.
However, if the seller or the party dun sa obligation can prove that he exercised diligence, or he is in
diligence
good
required.
Diligence
Tapos,
required.
and he is in good faith.
Then the law would consider him as to have complied substantially to what is required of him, and
So,
could be considered as
parang
payment.
may valid payment na kahit substantial compliance or substantial pa lamang ang performance. Kagaya dito sa example, 500 bags yung obligation to deliver. Ang na-deliver lang niya is 400 bags due to cement shortage. So, the seller in this case has or intended, yung seller naman really intended to complete the delivery of the 500 bags for not only for the cement shortage.
Siguro it's
So,
very
it's
important
substantial.
na ma-notice ninyo na ang peculiar dun sa case natin is that merong shortage ng cement.
Yes.
In the absence of that
Yun yung good
shortage,
faith. Oo,
hindi
hindi.
magpe-prevail
Oo.
yung doctrine na yan.
Yes.
Okay.
Yung 400 is substantially yung 400 is substantial performance kung 500. Kasi mas malaki yung na-comply kaysa dun sa hindi na-comply.
Alright.
So, ang consequence lang nun, yung 100 bags na hindi na i-deliver, ileles mo lang dun sa price na
Tama.
pag-usapan.
Hindi naman pwede siyang bayaran kasi it would
Hindi
be
naman din magbabayad si
benefit.
buyer ng buong 500 kung
Tama.
400 lang i-deliver mo. So, may reduction lang sa
That's
price.
correct. Okay. Okay, so that's as regards the doctrine of substantial compliance. Now, let's go dun sa partial performance naman. When can a
Yes.
partial performance be considered as payment as well? 1235.
Yes, so as to extinguish the obligation.
Yes.
Okay? So, 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with.
So this is
Okay
again
naman.
another exception to the
Yes.
general rule under Article 1233.
So, ang general rule natin is the integrity of prestation. Kailangan complete ang performance dahil kung hindi, walang valid payment. At kapag walang valid payment, hindi ma-extinguish ang obligation. So, ang una natin exception, 1234 ulit, yung doctrine of substantial compliance. At padalawa, 1235, ito naman yung partial performance.
Again, 1235 is an exception to the general rule under Article 1233,
Yes.
which means that, you know, there can be recovery. It will be allowed.
Yes, recovery is
despite-
allowed when incomplete or irregular performance is waived by the creditor.
Kasi in this case, it is deemed a waiver on the part
Yes.
of the creditor. If
It
the
is because then it is founded on the principle of stoppel.
Stopel.
Kasi hindi ka nag-express ng iyong objection.
So you're stopped from later on repudiating
Yes.
yung acceptance on your end, no?
Yes.
So, if the payment is incomplete or irregular, the creditor may properly reject
Reject
it,
it,
diba?
yes.
Supposedly. Ino-offer sa'yo, incomplete, irregular,
Yes.
wala yung integrity of prestation, wala yung identity of the prestation, pero tinanggap mo.
Yes.
Diba?
Yun yung
Pwede mo namang
principle.
i-reject.
Oo.
Diba?
Pero
So,
on your
yun.
part, you accepted it. Knowing that it is incomplete and irregular.
And because of that acceptance, the law considers that
He
you are
waives
waiving or
his
he is
right.
waiving his right and the whole obligation is extinguished in that
Extinguish.
case. Kasi unfair naman na tatanggapin mo tapos later on i-repudiate mo,
Yes.
tatanggi mo, di ba? So, esto ka.
Ang gulo mo.
Okay, magulo
Ganon,
ka.
magulo ka.
Oo, urong-sulong, bawal yun. So, there are requisites in the application of Article 1235.
So yung una, the obligee creditor knows that the performance is irregular or incomplete. At yung pangalawa, he accepts the performance without expressing any protest or objection.
Important na alam niya, he knows. Kasi
Yes.
kung may deceit naman on the part nung...
May fraud.
May fraud,
Oo,
ibang usapan yun.
Nakakala niya is
Complete.
No. Pero kung si creditor by himself has knowledge of the incompleteness or the irregularity of the performance, tapos
Tinanggap
inaccept niya
niya.
without any protest or objection, then he is deemed to have waived his right.
So, okay.
Oo.
And that would be considered as payment.
Yes,
That would
payment.
extinguish the obligation.
Yes.
So, for example,
Example.
X
Yes.
agreed to paint the house of Y. So, pipintahan ni X ang bahay ni Y.
Oo.
According to their stipulation, si X daw ay gagamit ng isang particular na brand ng paint. Huwag na tayo magbanggit kasi hindi naman tayo bayad.
Kaya so may particular
So, basta may
brand
particular brand ng paint. If si Y accepted the performance of X, knowing that the paint used was another brand, hindi yung brand na napag-usapan nila,
Oo.
and si Y walang in-express na rejection or protest or objection, then in that case, the obligation is deemed fully complied with.
Correct.
Yan.
Oo.
Kasi-
So may irregular dito, hindi siya complete siya,
Oo.
pero may irregularity dahil hindi yung brand yung nasunod.
Parang na-compromise din yung identity of the prestation. Oo.
Yes.
So, in that case, tinanggap mo eh. Alam mo naman na hindi yan yung brand
Brand-
A.
yes.
Si brand B naman yan. Eh, tinanggap mo. So, you're
You accepted without any protest or objection on your part.
So, unlike in Article 1234, where there is substantial performance, in this case, X is not liable for damages that may be suffered by Y.
Right.
What's the reason?
The reason is that the performance is considered complete or regular.
It shall be considered complete and
Oo.
regular. Okay? So, let's proceed to Article 1236, Attorney Uy.
Yeah, so the creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation unless there's stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor.
Okay. So, dito yung papasok dito yung usapin ng as a creditor, sino ba yung may obligasyon na magbayad sa iyo ng mga pagkakautang, di ba?
Yes. So, persons from whom the creditor must accept payment. So, sino ba, tama yung sinabi niya, yung as a creditor, sino-sino ba yung mga tao na
may right or may liability or may right
to
to
pay.
compel the creditor to accept payment. Ayan. So,
yun, yung person.
expressly provided naman yan by law. Una, the debtor. Siyempre,
Siyempre, may utang.
may utang. Kung
Himself.
creditor ka, nagbabayad sa yung debtor, of course, as a
You're bound to
creditor, you're
accept.
bound to accept what the debtor is paying you. Pangalawa, any person who has an interest in the obligation, like a guarantor.
Yes.
Any person provided na may interest siya. Halimbawa, guarantor, kasi yung guarantor, kapag hindi nagbayad ang principal debtor, hahabulin ni creditor si guarantor. So may interest siya doon. Gusto niya ma-extinguish yung obligation as much as possible. Pangatlo, a third person who has no interest in the obligation, when there is stipulation that he can make payment.
Pwede din naman pala na walang interest yung
Basta
magbabayad. Basta, it is stipulated that he can make payment.
Alright, so malinaw sa atin, Attorney Uy, na yung debtor, pwede i-compel si creditor to accept payment, yung person who has an interest in the agreement, or a third person kahit walang interest pero napag-usapan talaga sa agreement na pwede siya magbayad. Paano naman, Attorney Uy, kung hindi naman to kabat-usap? I mean, wala namang express agreement na pwedeng magbayad yung third person. Wala rin naman siyang interest, hindi naman siya yung debtor. Can that third person actually compel the creditor, or can he really pay for the debt?
So, the answer is, the creditor may refuse payment by a third person.
Pwede.
Pero, in case na si third person is nagbayad kay creditor, and yun namang third person yun has no interest, or siya naman ay hindi stipulated, and the creditor accepted the payment, what are the effects? Yan.
So, general rule, pwedeng refuse ni creditor, pero in the event natanggapin niya, ano ang effects noon, Attorney Uy?
So, una, if the payment is made without the knowledge or against the will of the debtor. Yung isa naman, yung if made with the knowledge of the debtor. Ito yung sinasabi natin na debtor, yung third person, walang interest, hindi stipulated na magbabayad, pero nagbayad, tapos sinanggap ni creditor. Ito yung consequence. So, ano ang consequence? If made without the knowledge or against the will of the debtor.
If it's against the will of the debtor, then
without the knowledge.
Or without the knowledge of the debtor, then the payer can recover from the debtor only insofar as the payment has been beneficial to the debtor. So, titingnan mo dyan kung naging beneficial ba sa part ng debtor yung payment na ginawa ni third person without or even against the will of the debtor himself.
So, in other words, the recovery is only up to the extent or amount of the debt at the time of payment.
Kasi take note guys, na halimbawa ako, may utang ako na 100 pesos. Kay Attorney Uy, for example, so I'm the debtor, he is the creditor. Then here comes a third person paying Attorney Uy 100 pesos without my knowledge. Attorney Uy accepted 100 pesos. However, at the time of the payment or prior to the payment, nakapag-down payment na ako dyan ng 50 pesos. So, ang tanong, pwede bang i-recover sa akin ni third person ang 100 pesos na binayad niya kay Attorney Uy?
Yes, the answer is no.
No.
Kasi
Why?
50 pesos lang because dahil without the knowledge and
without
without the
knowledge.
consent of the debtor, Attorney Maralig. So, the third person who pays without the knowledge and without the consent of the original debtor can recover only
Up to the extent.
insofar as the payment has been beneficial to the
The
original
debtor. Ako yung debtor, magkano ba yung naging benefit na nakuha ko?
The 50
pesos. So, he cannot collect that 100 pesos.
His remedy is to go against me.
Yes.
Kasi nag-accept ako ng mas malaki. Alam ko
Unjust
naman,
enrichment pa
unjust
naman.
enrichment. So, I must return the 50 pesos.
Yes. Okay, take note of that. However, Attorney Uy, paano naman kung may knowledge naman ni debtor? May knowledge.
If the payment by the third person is made with the knowledge of the debtor, the payer shall have the rights of reimbursement and subrogation. That is to recover what he has paid and to acquire all the rights of the creditor. Yung kanina, yung example mo kanina, ulit.
Okay, so in that case, 100 pesos, utang ko kay Attorney Uy. Okay, yung debtor, creditor siya. Here comes a third person paying 100 pesos to Attorney Uy. I have full knowledge, I consented. In that case, ano ang karapatan ni third person na nagbayad kay Attorney Uy? First muna, as regards my obligation to pay 100 pesos to Attorney Uy, what happens to that obligation?
That obligation is extinguished.
Kasi may full payment, di ba? So, si Attorney Uy, mawawala siya sa picture.
Yes. Itsapwera na ako. So, sila ng dalawa ngayon, si third person, the paying third person, and the original debtor.
Yan yung sinasabi kanina ni Attorney Uy na the third person steps into the shoes of the creditor. Merong right of reimbursement and subrogation. So, parang ang mangyayari, yung third person, yun ay magiging creditor ko.
Yes.
Sa kanya ako may utang ngayon.
Correct.
Alright, so Attorney Uy, so napag-usapan natin yan na yun nga, may third person, nagbayad sa'yo as a creditor, ako yung debtor. However, prior to the third person paying you, nakapag-down payment na talaga ako sa'yo ng 50 pesos eh, di ba? Eh kaso, may knowledge naman ako, may consent ako na si third person magbabayad ng 100 pesos kay Attorney Uy. Now, can the third person who paid 100 pesos to Attorney Uy with my knowledge and consent collect from me 100 pesos kahit nakapag-down payment ako ng 50 pesos?
Ngayon, ang answer na dito is yes.
Yes.
Kasi meron ng knowledge and consent ni, no, not consent, but only the knowledge.
May knowledge.
Yung may knowledge na si debtor na magbabayad si third person kay creditor sa akin. So, ang sabi dyan, ang consequence nun is the third person has a right to reimbursement and subrogation. Meaning, he has the right to recover what he has actually paid. So, ibig sabihin, kahit nagbayad si attorney Maralit sa akin ng partial payment of 50 pesos, pero si third person nagbayad pa rin sa akin ng 100, si third person has the right to collect 100 peso or the amount that he actually paid to me kay attorney Maralit.
Yes, okay. So, I cannot refuse to pay him 100
Eh, ano
pesos.
naman nangyari dun sa 50 pesos na binayad mo sa akin?
In that case, ako, si Attorney
Si
Uy,
attorney
may
Maralit
recourse.
na yung magkakaroon ng recourse sa akin.
Yes.
Yun.
Okay, may
Siya
recourse.
maghahabol.
Okay, so that's Article 1236 of the Civil Code. Now, let's proceed with Article 1237, which is actually related naman. So, ano ba ang 1237, Attorney Uy?
So, whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from mortgage, guarantee, or penalty. So, for purposes of Article 1237, let's distinguish subrogation and reimbursement. Nabanggit na natin yan kanina dun sa 1236.
So, linawin lang natin to reiterate, no? In subrogation, the person who pays for the debtor is put into the shoes of the creditor.
Yes.
So, the payer acquires not only the right to be reimbursed for what he has paid, but also all other rights which the creditor could have exercised pertaining to the credit either against the debtor or against third persons, be they guarantors or possessor of mortgages. So, as between subrogation and reimbursement, mas powerful tong subrogation. Kasi hindi na lang yung reimbursement, pero talagang extending all the rights of the creditor.
All rights na meron ng creditor, ipapamana sa'yo kung ano mo yun. Not only the right to receive payment, but also all rights
that the creditor has. How about reimbursement, Attorney Uy?
Yes, so in reimbursement, the third person entitled by reason of payment has merely the bare right to be refunded to the extent provided in the second paragraph of Article 1236 without the right to the guarantees and securities of the original obligation. In subrogation, however, there is no real extinction or extinguishment of the obligation, but only the change of creditor.
Okay, so pag subrogation pala,
nagpalit lang ng creditor.
So,
no real extinguishment. Ang reimbursement from the word itself, refund. Only refund.
That's right.
Without the right to guarantees and all other securities.
Okay. So, bigyan natin ito ng example, Attorney. Halimbawa, si debtor ng hiram kay creditor, let's say 10,000, 10,000 pesos. And si G, he is the guarantor. May guarantor. Nangyayari guys talaga sa mga utangan, may nag-garant. Okay?
Yes.
Para maintindihan ninyo, kaya nagkakaroon ng guarantor in the event na
hindi
ang
makabayad.
principal debtor ay hindi makabayad, si creditor pwede niyang habulin si guarantor as a security. Okay? So, let's say yun nga, may guarantor. Without the knowledge or consent of the debtor, let's just say si S, third person, nagbayad ng 10,000. So, tingnan nyo muna, may knowledge ba? Meron bang
May
consent? si debtor sa payment. So malinaw dito, walang knowledge, walang consent. In this case, Attorney Uy, can S claim reimbursement from the debtor D?
So in this case, si stranger, si S, can claim reimbursement from the debtor for the whole amount of 10,000 pesos in as much as the debtor was benefited up to that amount.
So, reimbursement lang yung meron siya. Take
Yes.
note na wala siyang right of subrogation because there was no consent, there was no knowledge.
Yes, the payment was made without the consent and knowledge
of the original debtor. And paano naman, Attorney Uy, kung halimbawa si debtor nung nagpapa-reimburse na si stranger S ay hindi makapag-reimburse, ano pa ang recourse ni S? Meron pa ba siyang recourse kung hindi makapagbayad si debtor?
Yes, so if the debtor cannot pay the third person, yung stranger, the latter cannot proceed against the guarantor because having paid without the consent of the debtor, the stranger third person is not entitled to subrogation. But if the payment was with the express or tacit approval of the debtor, then the third person would be entitled not merely to full reimbursement but also to subrogation. Meaning, may entitled din sa guarantee and securities.
Yes. So, ganun kahalaga yung knowledge and consent ng debtor whenever a third person will pay on behalf of the debtor. So, nung may knowledge na or consent si debtor of the payment of the stranger S, meron na rin siyang right as to the securities, no?
Subrogation.
Subrogation kasi, nung hindi na makapagbayad si debtor sa kanya, pwede niyang habulin ang guarantors. Kasi nga, fully consented naman and may knowledge naman si debtor doon.
Yes.
Okay. Suppose, however, Attorney Uy, the obligation of D is secured by a mortgage of a land owned by, let's say, the debtor. Ano pa? Yung may karapatan ba doon si
So,
seller?
the payment by a third person without the knowledge or against the will of the debtor cannot give the third person the right to subrogation. So, the third person can recover only insofar as the payment has been beneficial to the original debtor.
So again, kapag basta walang knowledge and consent, wala siyang karapatan sa mga
Reimbursement
collateral
only.
securities. Reimbursement only.
Yes.
Okay. Alright. So,
yes. So, let's
diretso tayo
proceed.
sa Article 1238. 1238, payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. Okay. So, ano ba ang sinasabi dyan sa Article 1238, Attorney Uy?
So, it talks about the payment made by a third person who does not intend to be reimbursed.
Nangyayari naman talaga yan.
So, ibig sabihin, donation.
Donation.
Oh.
And ang mahalaga dyan sa Article 1238, it requires the consent of
the debtor.
debtor.
Kasi yan ay donation, kailangan ng acceptance of the donee. Yung debtor dito naging donee.
Okay.
And yung third person is the donor.
Eh paano, Attorney Uy, kapag yung creditor tinanggap niya yung payment, kahit na walang consent
ng debtor. So if the creditor accepts the payment, even the payment made by the third person is without the consent of the original debtor, it shall be valid as to the creditor and the payor third person, although the debtor did not give his consent to the donation.
So, take note of that. Okay? So, ang peculiar sa 1238 as compared to 1237, sa 1238, walang intention to be reimbursed.
Yes.
Yung
So, wala namang problema doon sa third person kahit hindi i-reimburse.
Okay, mayaman siya.
Oo. May donation.
Donation nga yan.
Kailangan ng consent ng debtor. Pero kahit walang consent ng debtor, the payment is valid and it will cause the extinguishment of the obligation on the part of the creditor.
Okay. So, for example, si debtor, may utang siya kay creditor ng, let's say, 10,000 pesos and without the intention of being reimbursed, si stranger S paid the debtor's obligation. And B had previously accepted the generosity
Dito naman,
of
may
the
acceptance ng
third
donation.
person. So
in this case, the debtor is not liable to the third person and his obligation is extinguished. But if the debtor did not consent to the donation, the third person may recover from the debtor since there has been no donation, although originally the third person did not intend to be reimbursed. So, kaya mahalaga yung consent ng or yung acceptance ng debtor noong donation. Kasi later on, pag nagbago ang isip ni third person, pwede niyang singilin.
Kasi hindi nga considered as donation.
Okay, so however, the obligation of the debtor to the creditor is extinguished because the payment is valid as to the creditor who has accepted it.
Can D legally refuse to pay the stranger S and instead insist on paying C in this case, Attorney Oy?
So the answer is no.
Why?
So you see.
May pa why?